Welcome to Faith and Politics, a show dedicated to discussing issues surrounding the intersection of church, state, and politics, and the examination of whether you're allowing your faith to shape your politics or are you allowing your politics to shape your faith. In other words, what do you do when God and government come face to face? I'm your host, Orland Johnson, and let me introduce you to our roundtable of regularly scheduled panelists. We have with us today Mr. Todd McFarland, who's the Deputy General Counsel for the General Conference of the Seventh-day Adventist Church. We have Mr. Timothy Schultz, who's the President of First Amendment Partnership, an organization dedicated to protecting religious freedom for all Americans. We have Ms. Jo St. George, who's the Chief Legal Officer for the Women of Color for Equal Justice Law. And we have Dr. Timothy Golden, a Professor of Philosophy at Walla Walla University. Thank you all for being with us here today. Why don't we go ahead and get started? Our first segment is going to be about being deemed essential services. You know, during COVID, we had a lot of situations where public health crisis was going on. The states were creating a lot of different activities. However, one of the things that came up was the idea of what should be deemed an essential service. Ironically, grocery stores were essential services. We had drug stores that were essential services. We had liquor stores that were essential services. But for example, churches were not exempt as essential services. So now we have a situation where religious liberty bills have been created in a number of different states with the idea that churches should be essential services. Tim Schultz, I got to ask you, if churches are now going to be deemed essential services, where do we draw the line? Did it take too long? Did it go too far? Tell me and help me to understand.
Yeah, Orland, I think what happened is that in the early days of the pandemic, governments erred on the side of caution, and they were probably right to do that in the very early days. But then I think as we went into the later months, it became clear about how COVID was transmitted, and governments stubbornly stuck to their classifications that deemed marijuana dispensaries as essential services, but not churches. And that was just ridiculous. So the Supreme Court and the courts ultimately intervened. And I think some of these state bills might in some ways overcorrect and bind government's hands in future pandemics in ways that we may not want. But that's what's inevitably going to happen when government does something that might make sense at the time, but then fails to adjust as new evidence becomes available. So I think that on balance, the government was wrong, at least, beginning in about June of 2020. I think governments were overcorrecting and overregulating the fundamental rights that people have to worship in person.
But isn't there something strange about a pastor being on the same level as your surgeon or your doctor? And if you're going to say that churches are essential services, aren't there a number of other great opportunities and places people can go that would have helped them during the crisis as well? Why churches? Why go that route?
Well, I think just if you sort of look at what most matters to human flourishing, religious worship is one of those things that's at the core. Even if you're not religious, you have to understand that it is at the core for many other people. And to treat religion as a kind of hobby as opposed to a core part of individuals' life. And we do live, Orland, in bodies, right? Embodied worship, in-person worship is just very different than virtual worship, as you probably well know. And so I think government failing to recognize that was itself taking a kind of religious position. And I think that's always very dangerous.
But Todd, we have a lot of situations now where we have virtual services that were taking place and are still taking place. So why couldn't they just allow it to just remain virtual? What was the big deal about opening up the houses of worship?
Well, I think anyone who attends houses of worship on a regular basis understands that two things. First of all, there are certain functions at houses of worship that cannot be done virtually, certain sacraments, certain activities. Second, while virtual churches did provide an alternative, it was a poor substitute, right? The doctrine of community and the belief in community and church community coming together just cannot be fully replicated on Zoom. And it doesn't mean that Zoom is going to go away. Like, I know there's, Bible study classes and so forth that have started on Zoom and now will continue. Plus is that most people in the country now, even my 86-year-old mother, has used Zoom, right? But it's not something that can replace in-person services.
Well, Dr. Golden, I got to ask you, it can't replace in-person services, but it did. And people found ways to have communion. People found ways to even get people baptized at a later point in time, because all they were doing was limiting the numbers. But what is it about churches and what is it about that experience that made it critical for all of these states to want to codify it, not just simply use it as just a general policy?
Well, because I think what Todd and Tim say is generally true. The idea that you can separate yourself from worship and have that mediated by a computer electronically is problematic. I will say, however, that this is a pandemic in which over 1 million people have died, and the virus mutated and picked up different variants. And I have to say this: there is a difference between grocery stores and other merchants and a building where people will go to sing and pray. And what was clear throughout the pandemic, far beyond the early months of 2020 when it first started, is that the virus was spread through respiratory droplets, and that it was an airborne virus, and that it was spread through things like singing and speaking and that sort of thing. So I wouldn't say that it was overreaching at the beginning. I think sometimes as religious persons, we have to sort of check ourselves and ask ourselves what really is in the best interest of the public good. Now, certainly we're at a different place in the pandemic now than we were then, but I think there's a lot of interests to be balanced. And I don't think it's as easily dismissed as saying that the government overreached or that doctrines of body and community should always trump questions of public health. I think that Tim and Todd are correct in their assertions that church was sort of meant to be in person. I agree with that. And I don't like, frankly, the hold that Zoom has on us now, but that's a different question from whether or not we were right at the beginning of the pandemic and throughout its worst moments prior to vaccinations and clinical interventions, et cetera.
Well, Joe, I got to ask you this, because I heard a lot of pastors that were out there passing some really bad information on to their members. And part of the idea of trying to control messaging from a public safety standpoint, I kind of understood what the limitation was on churches. Let me know what your thoughts are on that.
Well, I have going to take the real extreme position that I was appalled by the regulation. Why? Because the federal regulations, 42 U.S. Code 5189E, defines nonprofits as essential service providers that specifically provide services during an emergency. These churches are always and have always been at the heart of providing emergency services. If it's not shelter, and it's always in the physical. So to try to suggest that you can separate the body from the mind and you can still practice your religion virtually alone is absurd, in my opinion. And it was totally unfair to the churches, especially when most, and if not all of the churches that I have worked with did everything to follow the distancing rules. And the Supreme Court then ruled in the case Roman Catholic Church Diocese against Cuomo that any harm against a church is irreparable, and physical being in a building while following safety measures was wrong. And so I think we really need to take a look at the data, though, too, with regards to mental health. The biggest fallout, other than the fact that chronic disease is the real reason why most people either died or suffered severely from this, from COVID, the mental health fallout is what is really critical that has to be addressed and is usually always addressed by religious institutions. So
thank you about that, Jill.
Out the equation was in my opinion, wrong.
Thank you, Joe, and I'm going to have to let that be the last word, but it sounds like we're understanding that in crisis, we've got to be a little bit different in our viewpoint. Let's go to our next segment. There's a concept out there that's called the ministerial exception. And there was a case that I remember hearing about where the First Amendment had barred a court from any type of employment discrimination, as it relates to anybody who's engaged with church activities. However, there was one lady who was told that that's not going to work for you because they're going to be adopting what we call the so-called ministerial exception. Joe, tell us what exactly this ministerial exception is and why it's important.
Well, it's important because in the case, our Supreme Court case, Our Lady of Guadalupe School versus Morrissey Bureau, that was decided July 8, 2020 by the Supreme Court, what they held was that the ministerial exception under the religious clause of the First Amendment forecloses employment discrimination claims against religious schools by teachers with religious duties. And so essentially before this decision, the ministerial exception was limited to only positions of that the title was either clergy, pastor, priest, imam. But this case, the Supreme Court said, no, we're going to, instead of focusing on titles, we're actually going to focus on the actual conduct or the work performed by the employee. And teachers are critical in sharing the faith of the institution. And so they decided to take the broader view of providing the protection of schools to allow for this exception to allow the institutions to choose who within the organization has the activity that is religious activity. And I think that is the best decision, because courts should not be engaging in determining what is religion and what isn't religion within each institution. Each institution has their own standards and practice, and focusing on the activity and letting the churches decide what those activities are that are religious is paramount.
But Todd, it seems to me that you can find yourself in a position where a church can overstep its boundaries. You can utilize this ministerial exception and put somebody in an awkward position just simply because they can rely on that. How do we make sure that there's a balancing test that takes place when this is happening?
Well, I think a couple of ways. First of all, despite the inequities that may happen, you cannot have courts and juries second guessing who can teach and who can teach and preach the faith, right? And that just has to be a baseline, because otherwise, what are you going to have to do? Well, did they fire the priest because he was, too old for age discrimination, or was it because of heresy? I think the way that you limit this is by making sure that the individuals who are covered by the ministerial exception are truly, either teaching or preaching the faith. Now, I will push back on my fellow panelists just a little bit. The original case, Hosanna Tabor, was dealing with a teacher. So I don't think the ministerial exception has just ever been applied, at least by the Supreme Court, only to your pastor, imam, priest, rabbi, et cetera. The difference between for Our Lady of Guadalupe and Hosanna Tabor was that in in Hosanna Tabor, the individual held a ministerial credential where they did not in the other case of Our Lady of Guadalupe. So, but I think the way you handle this is by limiting the scope of who is covered.
But Tim Golden, I got to ask you, how do we determine who's somebody who should be under this exception? Usually ministers of music sometimes are or are not. You have other different titles. I mean, who should end up making the call as to who falls under this exception? If it might be up to a church, they may pick everyone on a good day, or they may pick a very limited group on a bad day. Who should be making that call?
Well, I think this is one of those situations in which you have to sort of err on the side of caution, right? And you have to give churches some latitude in defining who falls under the title of minister and who doesn't. Because the real issue is that if the First Amendment means anything, it means sort of what Todd said a moment ago. We can't give the state any authority to ratify what is considered legitimate by ecclesial standards. We have to allow if in curtailing the free exercise of religion, the state would become really entangled with religion in a way that might lead to Establishment Clause problems. So those two clauses in the First Amendment, I think, work together. And I think you have to err on the side of caution. That said, there are concerns. And I think those concerns have to be addressed on a case-by-case basis, because while the ministerial exception is very important, we don't want it to be used as a pretext for other forms of discrimination. So I think this is the kind of tension we're going to continue to see in litigation, and we're going to see it addressed on a case-by-case basis.
So Tim Schultz, then I got to ask the question, if we're going to find ourselves with this tension and there could be a potential issue or violation of employment law, who should be making the call? I assume that we want the judges to be making that call and looking at it on a case-by-case basis, and we would have to have our religious organizations take a step back and allow those rulings to take place.
Well, I agree with the other panelists that we ought to give real deference to religious organizations in defining who is a minister, that is, who is propagating the faith. I think that's really important. I think that what I would say is that these are all cases that are going to be decided by courts. And so I would caution religious bodies not to abuse this right, because once you start abusing a right, once you start naming everybody in your organization as a minister, even when that's a real stretch, then courts become quite impatient with you. And I think that then filters into cases where we really are talking about legitimate ministerial positions. So I think that's the balance. I think that just as with the vaccine issue, right, just as with issues related to churches meeting during a pandemic, I do favor the fundamental First Amendment right of freedom of religion. I think it's really broad. But I also think that when that right is abused, it shrinks the right, because courts and the rest of the public becomes very impatient with you.
Well, it seems like there's a thought process that churches should be in a position where they're probably not going to abuse these rights. But I think there's so many laws that currently have been codified because churches actually were not doing things they wanted to do. I don't think the government ever wanted to be involved in marriage and divorce, but the way the church ended up happening and getting engaged, all of those things changed. How do we make sure that we are protecting individuals and making sure that the churches have their opportunity to make decisions on their own?
Can I make a point? I
Sure.
think the goal should be, the presumption should be the church, that the church is doing right. The presumption is theirs. Just like in any other employment case, employers get the presumption. Then it's the burden on the person who's claiming that the presumption is the pretext to now bring forth evidence to substantiate the pretext. And so the McDonnell-Douglas burden shifting rule should apply in this situation, giving the presumption to the church, because many churches do define the broad activity of a janitor as religious. Why? Because if the Bible says that cleanliness is a law of health, that is part of their practice. So I think what we need to recognize is that each religious group has their standards. If they can come into the court and establish their standard, they should automatically get that presumption. And that's how it equally applies to all religious groups, including those who are maybe atheists or those who are evolutionists. Those are still belief systems. So we have to focus on belief systems and what a person individually and collectively as a body defines as their religion, because the courts protect individual belief systems and how the individual practices also. So giving the presumption to the religion and put the burden on those who oppose to present the relevant evidence to establish pretext.
Joe, I'm going to have to let the last word be on that one, but I think we've kind of gotten ourselves understanding that the burden probably should be on the individuals having the problem, but the church should be given the benefit of the doubt when beginning the process. Let's go on to our next segment. Our next segment is a case that I found pretty interesting that I'd like for you guys to just give me some more clarification on. It was a court case that was entitled Fulton versus the City of Philadelphia. And that was a case in which we see this relationship between the Catholic Social Services and the City of Philadelphia. And many of you remember that when you started having these rules regarding same-sex marriage, and there were some organizations that were unwilling to place foster children or adopted children with same-sex couples, there were some groups that said that because of our religious beliefs, we've got to walk away from this, and the Catholic organizations appeared to be one of them. Well, the court now comes back and allows the Catholic organization to engage in that activity, which some would say is discrimination, and the City of Philadelphia seemed to go along with that as well. Can somebody give me some information to understand exactly how we got to that? Todd, help me understand what's going on here.
Sure. Well, this case all started with a newspaper article, right? Where I think Tim would know the answer to this probably better. One of the newspapers wrote an article about how certain providers in the city of Philadelphia would not provide foster services to same-sex couples. Now, there were other agencies that did provide. There had not been a single couple, same-sex or otherwise, who complained about these organizations and felt they'd been discriminated against. But based upon a newspaper article, the politicians in the city of Philadelphia and then the administrative agencies launched an investigation, ended up changing their rules several times. And as a result, Catholic Social Services end up getting disqualified from enrolling anyone new in their program because they only served individuals who were in line with their teachings, especially when it came to marriage. The case wound its way through the courts, ended up the Supreme Court, and eventually Catholic Social Services, Cheryl Fulton was the lead plaintiff, ended up winning in that case. And the Supreme Court said, listen, you've kept a certain amount of discretion here about who you're going to enforce your rules against and who you're not. And they struck down the disqualification of Catholic Services. And then after that, a lot of people were concerned, oh, they'll be able to get around this very quickly, but they didn't. The city of Philadelphia cut a deal with social services, and they're back providing on a regular full-time basis the services they were providing before.
But Tim Golden, I don't understand. We've said that you're going to be doing this service. It's a service that the government wants you to engage in. You've agreed to engage in it. But if you're going to discriminate against the types of couples that you could, quote unquote, be placing children with, here we're talking about same-sex marriage, but couldn't you easily be engaged in other forms of discrimination as well? So how do we get around this?
Well, I think we get around it by, again, I don't like these trite little phrases, but you do have to look at things case by case, and there are ways to discern the legitimacy of religious claims in these contexts. By the way, Todd, the newspaper was the Philadelphia Inquirer. That's the major newspaper in Philadelphia. Listen, I think when you're talking about situations like the one involving Catholic Social Services, the fact is that's an organization that has been around for a very long time. They've been engaged in foster care for a very long time. And to tell them that they can no longer do what they have been doing because they have a religious objection to providing homes for children to same-sex couples is, I think that's problematic. So this decision is probably the right decision. It does trouble me, though, because at times we can give so much deference to the free exercise of religion that we run up against real problems with other civil and constitutional rights. And I think we have to, again, this is a tension that will always be there in this type of litigation. And we have to manage that tension carefully by wise decisions that take into account a variety of factors that can determine whether or not the assertion of a First Amendment free exercise claim is legitimate or whether it's a pretext for something more nefarious.
But Joe, when something becomes the law of the land, like same-sex marriage, and we see these decisions made at some of the highest levels of the courts, and all of a sudden someone comes in and says, because I've been doing this a long time and I know what I'm doing, I should get the benefit of the doubt. The law of the land is supposed to, in my understanding, set the tone. And if you're not going to be in compliance with it, then you have to get out of the business. Why is it any different here, Joe?
Well, I think one of the issues that wasn't addressed is and what most people forget about the First Amendment is that it also has an establishment clause. And governments are not to, although most people narrowly define the establishment clause to say Congress can't establish a religion, it covers that legislators can't establish religious practices, because if you don't have a practice, you don't have a religion. And in this situation, governments have always used religious organizations to engage in practices to help facilitate and meet public health needs. And what that means is the government can then spend money across all religious groups to meet the needs of those religious groups. And so technically what that means is that they can fund a organization that supports LGBT adoptions, and fund them to do the same work that the Catholic diocese is doing, both maintain their faith practice, neither are their free exercise trampled, and then the state can also be consistent with its responsibility to not establish one practice of faith over another. And that's what we're really missing is religion or faith is not something that you just intellectualize. You practice it with your activity, whatever you eat, whatever you drink, whatever you do, and I'm quoting from the Bible, you do to your faith or belief system. And that's why, even in the case regarding the ministerial exception, the court focused on activity, because activity is what really defines your religious practice.
What happens now if this group decides, maybe I only want to place children with Catholics, and they don't actually do it in policy, but you start seeing that in practice? How do you jump in and deal with that?
Then if you are, that's what compliance and tracking is for. You have them report, and when you see that there's numbers diminishing in a particular group, you then put out a grant to give funding to another organization that has different religious beliefs, and you fund them to do the same thing. And that's how you bring equity amongst all religious groups, where each group can then practice their faith, be properly funded to do it, and meet the public health needs of the communities that they're in direct contact with.
Tim Schultz, let me give you the last word on that. What are your thoughts on this?
Well, the Obergefell decision that legalized same-sex marriage, gave same-sex couples the right to marry, did not answer these next-level questions about what happens to things like Catholic adoption agencies that dissent from that decision. But the court in Obergefell, and I think all 9 justices that signed on to this concept, has said that disagreement with the decision that belief in traditional marriage is held for reasonable and decent religious and philosophical reasons by tens of millions of people. And then so that unanimous Supreme Court was saying that, and then a unanimous Supreme Court in Fulton said that these Catholic agencies have a right under the First Amendment to do what they're doing. So I think that one can believe that same-sex marriage is the law of the land and that it's not ever going to be reversed, while at the same time believing that there is another very important right, the right of the First Amendment, for religious public service, related agencies like Catholic social services to do what they've always done, which is just to serve the public in a unique way that in this case places very hard to place children in foster care with loving and permanent families.
Thanks a lot. Well, let's go on to our last segment. Tim Golden, tell me something I don't know.
Here's something you don't know, Orland and panelists. The obiter dicta in Justice Clarence Thomas's concurring opinion in Dobbs versus Jackson Women's Health will propel the Democrats in the upcoming midterm elections and will not result in as much of a landslide as people thought, because a lot of people, even many conservatives, support abortion rights.
Wow. Tim Schultz, tell me something I don't know.
Orland, there's 2 groups of people who are uniquely overrepresented in the American adoption and foster care children system. It is deeply religious Americans and LGBT Americans. And of course, there's overlap between those 2 groups. And these 2 groups are doing, in their own unique ways, a lot of work to adopt and foster difficult to adopt and foster children. And we want to keep it that way. And so whatever we do in this policy area should really try to maintain a status quo, because that's what's in the best interest of children.
Wow. Todd, in 10 seconds, tell me something I don't know.
Despite them being deemed essential services during the pandemic and since, and quite a bit before, I never went into either a liquor store or a marijuana shop, despite the state thinking they were essential.
Joe, tell me something I don't know.
Yes, the OSHA regulations require employers to obtain a variance to make vaccinations a condition of employment, and they shouldn't be requiring it to employ you until they go and get a variance from OSHA. Very critical in the employment space.
Wow, thank you very much. Well, listen, we want to thank all of our panelists for being with us here today, and we want to invite you back next time for Faith in Politics. And just remember, if it's about God and government, it's about faith in politics. See you next time.